with respect to the first hypothetical, that's mine. And these, by the way, are as much as possible real, based on real cases and real ethics opinions. And so there are at least ethics opinions from around the country that opine in about some of the things we're talking about. So the first one, and what we hope is that these are hypotheticals chosen that are relevant to your law practice areas. So the first one is about a law firm that represented a plaintiff in a trademark and copyright litigation against a stamp manufacturer that was putting the plaintiff's photos on its stamps. The firm obtained a court order forbidding the company from continuing to use the plaintiff's photos. Believing that the company was violating the court order, lawyers and paralegals at the firm telephoned the company asking to purchase stamp with plaintiff's photos. When the firm sought sanctions against the company for violating the court order, the company in turn sought sanctions against the law firm. And as we frame this, should the court sanction the law firm for gathering evidence through deceit? In California, and probably in every jurisdiction in the world, lawyers are prohibited from lying. That's Ethics Rule 101. And so the easy answer for us on most of these hypotheticals is that when the lawyer is intentionally and knowingly misrepresenting, that's a no-no. Not always a no-no. And we could have titled this course, When Can Lawyers Lie? And I was joking with Pam outside that if the LA Times had picked that up, we'd be front page, lawyers teaching other lawyers how to lie. We didn't want that. So, but remember, we've all done this in one context where it's appropriate. It's the easy example. It's called puffery. And so when I'm in a settlement negotiation and I say, that's my client's last and best offer. Probably all said that. That's okay. In that context, that's okay. And that's even okay when you know that that's not the last and best offer. So it's not this hard and fast lying is never allowed, because that in every context is a lie. And what we're trying to do here is to show you generally where that lie stops and starts. So in this case, in the example that I gave you, we look at the rules, and what you should know for sure by now is that on November 1st of 2018, there were new state bar rules of professional conduct adopted in the state of California. So now we're more in line with the other 49 states in relying on essentially the ABA rules. And here, one of the rules that's relevant to the analysis is Rule 4.1 of the new rules. And that states that in the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. That's also something that you would see in Business and Professions Code 6106, which is the Moral Turpitude statute, and it's a catch-all for a lot of bad lawyer conduct. If it's something that was dishonest or corrupt, then lawyers are prohibited from doing that, both under 4.1 and under 6106. And so here in the hypothetical, to the extent that the lawyer is knowingly making a false statement in terms of the representation to the entity that's making the stamps, that's a violation, and that's something that could be prosecuted by the state bar. Likewise, in 4.1b, failure to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. So in the hypotheticals I've set forth, there's a misrepresentation insofar as there's a failure to disclose a material fact. The other thing that you may have caught in at least that hypothetical is the ex parte communication. And there, you all should know, that a lawyer shall not communicate directly or indirectly about the subject of a representation with a person the lawyer knows to be represented by another lawyer in the matter. And in the hypotheticals we've set it up, that's another issue that plays out there. So So two things in that hypothetical. One would be the dishonest conduct insofar as how to obtain the stamp that would be a material piece in the litigation, and then two, communicating with a represented party. I have a third one. I don't think it's on a slide. Well, Rizza will talk about that in a second. But the third one in my mind, and I'm somebody who is a litigator, tries a lot of cases. It's Rizza and I are actually waiting for a jury to finish deliberation after spending 2 weeks in Riverside. So we know our way around the courtroom. But the third one to me in this example, so we have the dishonesty, we have the ex parte communication, and then we just have the dumb lawyer. Because in my hypothetical, the lawyer at a minimum should have had an investigator, because now the lawyer, the law office are potentially making themselves witnesses, and you don't want to do that, so you should always be using a third-party investigator. There is a case on point. Rizza, can you talk to us about the case?
Sure. So this hypothetical comes from a real case, and it's the Apple Corps Limited versus International Collector Society. So this case involved Apple Corps, not that Apple, but the Beatles Apple, where there was a agreement between the Apple Corporation and International Collector Society, and they made different things with different people's likenesses. In this case, it was stamps with the Beatles pictures on it. The settlement agreement provided that they could only use the Beatles photos on certain sorts of stamps, but the corporation believed that they were using those images on other kinds of stamps that were prohibited by the settlement agreement. So what ended up happening was they would call in to the stamp people's office and say, hey, I'd like to buy some stamps. And then they would offer them stamps, including the ones that were prohibited. In this particular case, I don't even believe they asked for those particular prohibited stamps. They just offered them sua sponte. So the court found that those misrepresentations they made were okay, because the only misrepresentations made by the callers were that they were normal consumers and not paralegals from the law firm, because all they were saying was, can I buy some stamps? And the court found that it wasn't a communication with a represented party, because they were just speaking to sales representatives from the stamp sellers, as opposed to people higher up on the stamp sellers' food chain who made actual litigation decisions. So they were okay with them speaking to sales representatives. And that basically their conduct was okay because they were trying to uncover corporate misconduct, and but for having called in and asked for the stamps, they wouldn't have been aware that the stamp company was selling stamps with the Beatles likeness on them without them.
Why were they even used making misrepresentation? They didn't represent.
Yeah, correct. And that's what the court found. They just found that, well, they weren't making misrepresentations to them specifically. They were just saying, I'm Joe Smith, I would like to buy some stamps. They didn't find that to be a misrepresentation in the same way that that would fall under 4.1, because all they were doing was asking them to sell them stamps.